Very much indeed, Ms. Ball.
I'm grateful.
Mr. Ross.
Good afternoon, my lord. If it is all right with my lord, may the senior counsel open with rebuttals.
You must do it in whichever order suits you, Mr. Ross.
I am grateful, my
Don't
lord.
have to ask, just get on with it.
My lordship, could you please turn to my apologies. The black bundle on both sides is the respondent's bundle to use.
Yes, that's all right.
My apologies, the one to your right arm.
That one.
My lord,
Yep.
if we would please open to side tab 10, which is the very last one. And counsel will invite the lord to actually turn to page 352.
Oh, Pinochet again.
My lord.
Yep.
This is the first submission that my learned friends started with. If I could please, as you already know, have heard the case facts before, as my lord had already heard the case facts before, turn to the next page, 353. In the middle of the page, the quote starts at indicator Q with, "It is important not to."
Yes.
It is important not to overstate what is being decided. It was suggested in argument that a decision setting aside the order of 25 November 1998 would lead to a position where judges would be unable to sit on cases involving charities in whose work they are involved. It is suggested that, because of such involvement, a judge would be disqualified. That is not correct. The facts of the present case are exceptional. The critical elements are: 1, that Amnesty International was a party to the appeal; 2, that AI was joined in order to argue for a particular result; 3, that a judge was director of a charity closely allied to AI and sharing, in this respect, AI's objects, my apologies. Only in cases where a judge is taking an active role as a trustee or director of a charity, which is closely allied and acting with a party to the litigation, should a judge normally be concerned either to recuse himself or to disclose the position of the parties. My lord, none of these critical elements have occurred in the instant case, and as your lordship will hear from counsel's third submission, Pinochet should not be taken into consideration in the instant case. This promotion of a cause argument by my learned friend has forwarded is based upon the premise that Lord Hoffman was so intrinsically tied into Amnesty International that their goal were his goals. It will be made apparent that Dr. Hawk does not have anywhere near this level of proximity with the RSPB.
Not the same connection as Lord Hoffman had to Amnesty International.
My apologies, that is correct.
Is that right? He was a director, wasn't he?
Dr. Hawk?
No, Lord Hoffman.
Lord Hoffman was, but Dr. Hawk was not. He was a mere member.
I see. That's your point, right?
Would my lordship please turn to page 354?
Yeah.
This will open up to counsel's, my apologies, my learned friend's sixth submission, Lesage and Mauritius Bank.
Yes.
This case can easily be distinguished as a judge in this case is showing outright contempt for the claimant, and a letter which had privileged information which was not meant for the judge had adversely affected his defense. However, in the instant case, Dr. Hawk does not show contempt and is not in possession of any privileged information.
Right. Now, where do we find those things?
That will be located on paragraph 50 and 55, which should be the next page, so page 355.
Judges have been informed of material which was privileged and, moreover, adverse to the claimant. Yes, and 55.
Correct. My apology, it goes from 50 to 55, including all of 55. Essentially, from 50 to including 55, it is the judge being accused of being hostile towards the claimant.
Who's asking the questions in paragraph 55? One of the judges?
That would be the judge, my lord.
I put it to you.
Yes.
I see. Right.
And the claimant in that situation, the defendant, my apologies, is not being allowed a response time, which is what this is showing, and that was held to be hostile.
Yes.
I'm grateful, my lord. Would my lordship please turn to page 357? This will be my learned friend's second submission, Davidson and Scottish Ministers, 2004. My lord, could you please turn to 358?
Yep.
It is quoted in the case at the start of the page, indicator R, that a risk of apparent bias. That a risk of apparent bias was liable to arise where a judge was called upon to rule judicially on the effect of legislation which he or she had drafted or promoted during the parliamentary process. And a very clear assurances he had given to Parliament. Your Lordship, not only is the bias extremely apparent in this case, but Lord Hardy has also breached the separation of powers. Lord Hardy effectively drafted legislation and then heard a case where he promised his honor would be on the line. Again, counsel makes the point that this case has nothing to do with mere membership or anything on the lower end of a scale, if you will, my lord, of appearance of bias.
Well, I think what's said against you is that Dr. Hawke is a campaigner for the RSPB. He's identified himself with those aims. His honour, as it were, is on the line in their service. That's what's said, isn't it?
My lordship, a quote from the RSPB website, if you will. It is included in the case 10 as well, too, on the very beginning. On page 349.
This is the RSPB website, is it?
That is correct, my lord.
Right.
My lordship,
Has Miss Boff seen these?
as for the case facts, the RSPB is mentioned in the...
No. Has Miss Boff seen that you are relying on this material?
My apologies, my lord. It is not into the skeleton as the RSPB was mentioned in the case facts.
Well, yes, but if you're going to show us a document, you really must show it to her as well, mustn't you? Got a spare copy for her. It's a bit like not disclosing the documents.
Page 349.
No, we've only been provided with up to page 346.
Well, see what you can do with it, Miss Boff, and we'll hear you afterwards. But for the moment, I'm going to look at it to see whether it's, in order to be able to see whether it may cause you any embarrassment. What do you want to say about it?
My apologies, my lordship.
Well, it's not you.
Dr. Hawke was a part-time, as per the case facts, campaigner for the RSPB.
Yeah.
The website quotes, the main aims of being an RSPB campaigner are to remind your local MP that environmental issues are important and to urge them to take positive action. Campaigners for the RSPB write into their local MP if the RSPB asks for them. With great respect to my learned friends of the appellant has failed to prove what Dr. Hawke actually campaigns for. Thus, this is one disconnect between the claim of apparent of bias.
But this is simply what they're advertising for as people that they'd like to help them. How does that tell us what Dr. Hawke did?
That is a very good question, my lord, and goes towards actually my exact point as to we do not know what Dr. Hawke was campaigning for.
All right. So what your point is, it may be as little as this.
Correct, my lord.
Right.
In regards to the claim of bias, senior counsel will be arguing three main points. The first is that the appearance of bias and real danger tests have been clarified and brought in line with the ECH Article 6. Therefore, when Mr. Justice Giles made his decision based upon the rules at the time, he was correct. But counsel would also ensure that his decision still works within the new framework set down by Lord Hope in Porter and McGill, which my learned friends have already raised.
Yes.
Your Lordship, counsel is going to use Damien McCarthy and the Bar Standards Boards to reinforce that rule, but that is not necessary other than to make the point that a level of proximity is required between the two parties accused of bias, and that the legal definition, appearance of bias, is a misnomer that may confuse a layman not versed in the legal definition. That will be shown by counsel's next two submissions.
Right.
The second submission from BPC is that in order to prove an appearance of bias, close proximity must be shown. Merely being a member is not enough. The third and final submission is the House of Lords decision in Harlow and Secretary of State of the Home Department 2009 is analogous to the instant case based upon almost identical facts which were held that no appearance of bias emerged. What these precedents and cases will prove is that Dr. Hawke does not appear biased and thus his decision is still valid. That means compulsory purchase order is valid, and as such, counsel invites my lord to dismiss the appeal for ground one.
Right.
If it pleases my lord, council will enter its first submission.
Yes.
Your lordship, could you please turn to side tab blue 5. This will be page 211, reported in the England and Wales High Court Administration at page 661, ICALO and Solicitors Regulation Authority, 2013, further referred to as ICALO. Would my lord like a summary of the case facts?
Well, no, I remember the case. What was the connection or the appearance of bias which was relied on against the gentleman concerned?
To that end, my lord, may I direct you to top tab 2, and this next part should answer that submission.
Hey, gentleman, it was a judge. No, it was. This was the solicitor. Yes. Okay. Go on.
My lord, top tab 2 should open up to page 219.
Yep.
In the indented paragraph 25, my lord, this is a list the court considers what type of circumstances might give rise to an appearance of bias.
Yes.
The sentence in line with indicator B in the middle of the page starts with, everything will depend on the facts.
Yes.
Everything will depend on the facts, which may include the nature of the issue to be decided. We cannot, however, conceive of circumstances in which an objection can be soundly based on. We will skip the massive list and go down to indicator C. The quote starts with, history nor that of.
Yes.
History nor that of any member of the judge's family or previous political associations or membership of social or sporting or charitable bodies. My lord, a charitable body is what the court is discussing today. What Justice Law and Swift, with the help from numerous sources stated above, is that the courts would not consider circumstances in which membership of a charitable body or any other large organization, such as in the instant case, gives rise to the appearance of bias. The RSPB has over 1 million members domestically, and as per the case facts, there is no correlation between Dr. Hawk and the directors of RSPB.
Why does there have to be a connection with the directors?
As per the case facts of Pinochet,
Yes, well, there was, but why is that necessary in order to establish an interest in the outcome which prevents him from acting impartially?
I am grateful for the question, my lord. Towards the interest in action, if Dr. Hawk is merely a member, it cannot be shown that his interests are aligned with the actual organization. As such, the RSPB sends out a mail order and gives access to his members to over 149 nature reserves. Thus, counsel will argue that Dr. Hawk's membership involved in this is more towards his use of the paper and knowledge gained from that and the entrance to the membership sites.
Right. Thank you.
Counsel will invite his lordship to the next page, 220. Starts with paragraph 43, starts with indicator S. The quote starts with, it is clear that there is no.
Yes.
It is clear that there is no requirement for an individual sitting in a judicial capacity to disclose every previous activity or association that he or she may have had, whether or not the activity or association is capable of forming the basis for a reasonable apprehension of bias.
Oh, quite. Go on.
The duty extends only to activities or associations which would or might provide the basis for such a reasonable apprehension, since, as we have said, it is well established that mere fact that Mr. McCarty had previously held an appointment as an educator for the respondent could not of itself give rise to a reasonable apprehension of bias. There can have been no general duty to him to disclose his previous appointment. Your Lordship, this is worse than the instant case, as to the solicitor have previously found against the claimant. Dr. Hawk did not disclose his membership with the RSPB because, viewed objectively, it has no bearing on the current case as proven by the next submission.
I'm not sure he had actually found against the appellant before, had he?
He was working on
he was one of the solicitors
on the education panel.
Adjudication panel.
Yep.
Yes.
That had the disciplinary powers over the solicitors, and
That's right.
Yeah, and they had reviewed. My apologies, correct. They had reviewed him. They hadn't found against him. No. My apologies in the word.
Right. Okay. Thank you.
If it pleases your lordship, counsel will enter its third and final submission.
All right.
I'm grateful, my lord. Could you please turn to red tab 6, which should open up to page 227.
Yes.
My lord, this is the case of Hilo and Secretary of State for the Home Department, 2009, which can be found in the second volume of the All England Reports communicated at 1031. Will further be referred to as Hilo.
Yes.
Will my lordship like a summary of the case facts?
No, this is Lady Cosgrove, isn't it?
Correct.
Yeah.
Where it was contended that her membership with the International Jewish Association of Lawyers was conceivably beheld bias against a Palestinian woman.
Yes.
This case was held in the House of Lords, 5 judges in agreement and none dissenting. Lordship, this case is analogous to the instant case in the fact that the claim was based on the appearance of bias and because of a membership which Lady Cosgrove failed to mention. In Hilo, it is even worse for the fact that the quarterly publication the lady was receiving was sometimes fervently anti-Palestinian. In the instant case, Dr. Hawk is part of a volunteer organization where members blog about flora and fauna.
Yes.
Council invites your lordship to turn to top tab 3, which should open to page 237.
Got it.
Paragraph 40, in line with indicator D. The quote from Lord Mance involves the appellant seeking assistance from ex parte Pinochet and starts with, however, in my opinion.
Yes.
However, in my opinion, the present case is a long way away from ex parte Pinochet, since association was not a party to or in any way concerned with, or so far as it appears even aware of, as same as in the instant case, RSPB was not aware of, the proceedings involving Ms. Hilo. Even when proceedings are brought, for example, by a bar association mere membership of the association as opposed to active involvement in its affair or in the institution of its proceedings may not bring the principle in ex parte Pinochet into play.
So would it have made any difference if she'd been actively involved in the affairs of the organisation?
And Lord Mance's definition of active involvement is more to an administration level than mere support of it.
Right.
Council will direct your lordship on the same page to paragraph 38, in line with indicator E. This one is halfway through, and the quote starts with, this revealed on 30 November 2004. This revealed on 30 November 2004 that Lady Cosgrove is a member of the International Association of Jewish Lawyers and Jurists, and later that she was, my apologies, that she as a member of the Outer House, together with Lord Kaplan of the Inner House, was a founding member of a Scottish branch of the association, welcoming participants to an inaugural meeting in the Parliament House, the Court of Session's home, on 30 November 1997. My lord, not only was Lady Cosgrove a prestigious founding member, she also had the inauguration at the very building where she decided against Hilo. Lord Hope, my apologies.
What's the basis for saying that the organisation had any animosity against Mr. Hilo? Miss Hilo, I'm sorry.
I'm grateful for the question, my lord. This would be found, anti-Israel, this is page, yes, the judges. Hilo contend the association was inter alia, anti-Palestinian, antipathetic to the PLO, and supportive of Israel.
Yes. And the, right, all right, that's it, is it? Yep.
My lord, my apologies, I've already said that. Lord Hope of Craighead puts into perspective the issue of RSPB's quarterly journal with a quote that council will direct your lordship to. My lord, could you please grab top tab 4? This should open up to page 230.
Right.
Indicator F on paragraph 6. The quote starts at the beginning at 6 with, but the fair-minded. But the fair-minded and informed observer would, as I've said, put the material published in justice on which Mr. Bovey relied into context. The first point is that the material on which relied was one-sided of what had been published. It is incomplete. If one is looking for a balanced and fair-minded presentation of what is available to the reader, one would need to see the other side. It is clear from the contents listed at the front of each edition that some of the material that was published was of genuine interest to a lawyer. Your lordship, in the instant case, the material that was published is of genuine interest to Dr. Hawk. Parallel with Hilo, the RSPB.
Yes, but is it enough that it's interesting to him? The point about Lady Cosgrove was that she was a member of an association of jurists.
Correct.
And the association published materials such as decisions of the courts in Israel. So it was nothing to do with any animosity between Israel and adjoining territories, or at least that's what Lord Hope is saying.
I am grateful for the question, my lord, and that is the exact same parallel situation that we have here, whereas the RSPB is not stating anything outwardly hostile towards the ECH, or even has stated anything in a line. I'm grateful, my lord.
Okay, right.
I'll skip that. You agree with that? If I may invite his lordship, council will continue reading on the next page, 231. My apologies, my lordship. My time is up. However, if my lordship would allow me to finish off the last paragraph and my submission.
Well, you've got a sentence and a half. Otherwise, you'll have, if you can't do it in that, you'll have to.
We will skip to my submission.
I should.
In conclusion, round one is concerned with Dr. Hawk's failure to mention his membership with the RSPB, the Quarterly Journal, and his part-time campaigns. These complaints are analogous to the case of Hilo and Secretary of State for the Home Department 2009. Just like Hilo, none of these issues were found to prove the appearance of bias for want of proximity. The case of Ighalo provides a list where the bias cannot be found, and being a member of the charity is one of those listed. With great respect to my learned friend, senior counsel has failed to explain how a campaigner raises a real danger of bias, as per the informed observer rule, in relation to a large charity organization such as the RSPB. How then can Dr. Hawk possibly be treated the same way as the director of a company, or how can he be assumed to bring RSPB into the proceedings, such as what happened in Ex parte Pinochet? It is also addressed in Hilo how a publication cannot in any way have assumed to influence Dr. Hawk. Just proving appearance of bias in one example is insufficient to tie in the necessary proximity.
Well, I think we've got that. It sounds as if you've gone somewhat beyond your sentence and a half, Mr. Ross.
If my lordship has any further questions?
No, thank you very much.
I am grateful,
Thank
my
you
lord.
for your help.